And so I want to welcome everyone to tonight's presentation, Florida Ethics, an overview and update. Our presenter is Gray Schafer, Assistant General Counsel with the Florida Commission on Ethics. Little housekeeping note, if you have questions as we go, type them in the chat and we will either save them for the end, or if it looks like it needs to be addressed right at the moment, we'll do that then. And without further ado, I will give it away to Mr. Schafer to introduce himself further.
Thank you, Amy. As she said, my name is Gray Schafer. I'm the Assistant General Counsel of the State Ethics Commission. I've been at the Commission for a little bit over 10 years. I want to thank you, first of all, for having me here tonight and giving me the chance to speak to you all about the state ethics laws. I think I spoke to soil and water conservation districts back in 2019 prior to COVID. I know that I had a really good time at that particular conference, and so I'm happy to be back together with you here tonight. I want to thank Amy in particular tonight. She really helped pull all the presentation materials together and let me know exactly where I needed to be to have this work. These Zoom lectures are not always easy to pull off, and so she's done everything she can to make sure this goes smoothly. Um, what we can't predict is the weather. I'm in Tallahassee, and there's currently a thunder and lightning storm going on right outside the window behind me. And so if you lose me during this presentation, it's not intentional on my part. Hopefully we can ride out the storm here together. Um, I'm going to try to share my screen and pull up my PowerPoint.
Let's make sure the images we are getting are accurate. That's the side that controls the pictures on the ground. It's the
Okay. Now, hopefully everyone can see that. We have a lot of ground to cover the next hour together. I'm going to try to move quickly. As Amy said, though, if there's questions that come along and you want to put them in the chat, I'll try to take a break every 10 minutes or so to answer any questions that have come in up to that point, and we'll see if we have time at the end of the hour as well. But the best piece of advice I can give you before I even get started is to pay special attention to the last slide of this presentation. I put the contact information for the State Ethics Commission and my personal email address on that last slide. Now, a lot of these issues we're going to be talking about tonight are fairly straightforward, but some of them are tricky. They can be nuanced. So if you ever just want to talk about one of these ethics issues with someone who really works in it day to day, please give us a call at the Ethics Commission. And you can ask to speak with one of the attorneys. You can ask to speak with me in particular. Our job is to help you navigate these laws that you are subject to. And so please don't hesitate to reach out to us because it's really why we're there. Now, and maybe you weren't even able to make that particular conference. Maybe you weren't even elected your board yet. So I want to start here by talking about the background of the Ethics Commission. A lot of people in Florida don't even know that the State Ethics Commission exists, and even if they know the agencies around, they don't have a good understanding on what exactly it is that the Ethics Commission does. So I just want to take a few minutes and talk to you about the history of the Ethics Commission, how it was created, and talk with you a little bit about the different responsibilities that the commission has. So jump in a time machine with me. We're going to wind back the clock to the mid 70s. And what was the big ethics issue going on in our country at that time? It was Watergate, right? Because of Watergate, there was renewed interest in ethics across the country, not just at the federal level, but at the state and the local level as well. And to address that, the Florida voters approved some amendments to the state constitution. They put new language in the Constitution that says a public office is a public trust, which I don't think anyone would disagree with. But in and of itself, that language doesn't have a whole lot of teeth. And so, thank goodness, the voters also approved some other changes right in the Constitution. They actually created a brand new amendment to the Constitution called the Sunshine Amendment. That's found in Article 2, Section 8 of the Constitution. And in that amendment, they called for certain public officers and employees to start filing an annual financial disclosure form. They called for the creation of a series of ethics laws that would apply to public officers and employees in Florida, both state and local. And they called for the creation of an independent body that would oversee the disclosure process and that would kind of police those state ethics laws. And an independent body is obviously the State Ethics Commission. It's a 9-member body. It's made up of private citizens who enforce the state's ethics laws. Now, the commission only has the authority to enforce certain prohibitions, though. And the Sunshine Amendment, the state constitution, does set out some of them. Like I said, it sets out the requirement to file financial disclosure, sets out a couple different prohibitions we're going to be discussing tonight. But the voters in the Constitution also gave the state legislature the ability to pass additional, more specific laws about ethics. And so, right there in the 70s, the legislature passed a whole series of ethics laws, and it grouped them together into one chapter of the Florida statutes. And as I'm sure you know, the Florida statutes set out all the rules, all the laws in our state. The statutes themselves are broken up into different chapters. Chapter 112 is where all of the ethics laws can be found. And that's why most of the laws I'm going to be talking about tonight have the prefix 112 in front of them. And we just call chapter 112 the Code of Ethics. So if you hear me talking about the Code of Ethics tonight, what I'm referring to are the different ethics laws that are found in the Florida statutes that are grouped together in chapter 112. Now, the laws in the Code of Ethics set out obviously standards of conduct for Florida public officers and employees, but those laws are limited. The commission can't go beyond them. So if you as a public officer, if you don't do something that's not addressed by one of the laws in the Code of Ethics, the Ethics Commission has no authority to act, okay, even if the action is morally wrong. And that's something I think a lot of people don't understand. You know, we're not the commission on morality. We're the commission on ethics. And the laws define what the standards of ethical conduct are for public officers in Florida. For instance, the Code of Ethics does not cover the Sunshine Law or the laws about open meetings. You know, if a conservation board supervisor has an outside the sunshine conversation with another supervisor on their board, okay, that's against the law, but the sunshine law that governs that is outside the Code of Ethics. It's overseen by the Attorney General's office. So at the Ethics Commission, we don't have any involvement in sunshine law matters. Also, the code just applies to conduct that you commit in your public capacity as a district supervisor. Okay, any conduct that you commit in your private capacity that's unrelated to your public duties is going to be outside our authority at the Ethics Commission. Now you can see there's a bullet point up there about the structure of the commission. We're set up in a pretty unique way. We're a joint legislative entity. We're part of both the Florida House and the Florida Senate. There's 9 commissioners. They each serve 2-year terms. The governor appoints 5 of them, and the Senate president and the Speaker of the House, they each appoint 2 members. And it's split up by law so that no more than 5 of the 9 commissioners can be from the same political party at once, which is obviously in place to make sure that votes don't fall along party lines. Since I started working at the commission, we've had a variety of commissioners from all over the state, from the Keys all the way up through the Panhandle. We've had lawyers and retired judges and retired politicians, which I guess you might anticipate. But we've also had, I don't know, we've had accountants. We've had just laymen off the street. We even had Ronald's Secret Service bodyguards serving on the commission when I first started. So it's a really good mixture of people. Really, the only requirement of it is you have to be a private citizen. You can't be a public officer or a lobbyist if you want to serve on the Ethics Commission. Now, the commission has several different responsibilities that I just want to run down real quickly for you because I think, especially on this slide, this is where we really can help you as a district supervisor. And that's in the way that we interpret the Code of Ethics and apply it to different situations that arise. If you have a question as a district supervisor, or even if you're a district employee and you're listening to this, and you want to get in touch with us at the Ethics Commission, part of our job is to help analyze your question and get you an answer to it in terms of whether or not you can do something without violating one of these ethics laws. Now, there's 3 different ways we respond to an opinion request. They're laid out there up on the slide. First, if the question is pretty straightforward, and it's something that's clearly addressed in the laws, or it's a question the commission has clearly addressed before, we as attorneys can just give you advice right over the telephone. That answers probably 2/3 of the questions that we get at the commission. They deal with fairly well-settled issues where you can give advice right there to the requester over the phone without even having to take it any further. Now, if the question is a little bit trickier, because let's say the facts are a little bit more complicated and we just want to make sure that we have everything straight before we give you a recommendation, we might ask you to send us the question through a letter or an email instead. Now, letters and emails go into our executive director, Carrie Stillman. You can see her email up there on the slide. She then assigns it to one of the attorneys at the commission. There's five of us that work as attorneys for the commission, and we'll work to get you a written response to your email, your letter. It usually takes, I don't know, between 2 or 3 weeks, sometimes less, to get you an answer. I usually try to turn things around in just a couple of days so you're able to get a quick answer to your question. I will say that letters and emails, we only have to be careful to make sure, again, that there's just some precedent backing up what we're recommending. We have to make sure that what we're recommending is supported by the language of the statute or by opinions the commission has issued in the past. But as long as it is, we can answer the question right there through a written response. Now, if there's no guidance out there, and it's a brand new issue that's never come up before, or honestly, if it's a political hot potato of an issue that we're just a little bit nervous addressing as staff, then we come to the third kind of opinion. These are formal opinions. If you've ever read a Supreme Court of Florida opinion, that's what they kind of read like. They're usually a little bit longer. The commission meets every 6 weeks in Tallahassee. All the commissioners come in from all over the state, and usually there's one or two different formal opinions for it to consider at its meetings. And once the commission signs off on a formal opinion, we can then use it as guidance if the same question arises in the future. My best piece of advice, I know I've already told you this, if you have an ethics matter that arises in the future, please get in touch with us. Either give us a call or shoot us an email. We'll respond using one of these opinion methods and hopefully get you a quick answer to your question. I think sometimes people get hesitant to contact us because they're afraid that if we don't like what they're saying, we might commence some type of complaint proceeding or commence some type of investigation against them. That is not currently in the statutes. We don't have the authority to do that. We don't have the authority to self-initiate any process at the commission. Every couple of years, that's proposed over at the legislature to give the Ethics Commission the authority to self-initiate an investigation. It's never gone the distance. That's not currently in the laws. We don't have the power to do that. And so the good news for you then is there's no downside in contacting us. Again, we'll respond using one of these different opinion methods and get you a quick answer to your question. Now, before I move on, let me just plug the commission's website here. This is where the formal opinions the commission approves, this is where they are stored and housed. They're uploaded to the commission's website, which is ethics.state.fl.us. If you're ever curious, there is an opinion bank on that website. You can search for opinions by year if you know roughly when they were issued. Or if you're looking just for a particular subject matter, you can type in a couple of keywords or key phrases, hit enter, and you'll get all the different hits where those phrases turn up in opinions. And you can kind of winnow down your research from there. The commission's website also contains other useful information. It has links to all of our different forms, including the gift form I'm going to be talking about at the end of my comments. It also has links to different ethics training videos. We offer free recorded trainings on our website. If your district is an independent special district, you are required as an elected officer of it to get 4 hours of ethics training each year. This lecture tonight will be about an hour long. It'll count for one of those hours for the 2025 calendar year. But if you need to pick up a couple of other hours very quickly, there's free training available on our website that you can just click on and listen to. There's also a link on the website to look up financial disclosure forms that have been filed. You can search for those. It's where all the commission meeting materials are placed prior to the meetings. And the last thing there is a link for anyone who wants to file an ethics complaint. And that's the other responsibility of the commission. This is kind of the flip side of the coin here. I just want to take some of the mystery out of what happens when an ethics complaint is filed in case an ethics complaint is ever filed against one of you. And I want to emphasize at each stage of the complaint process, you will have the full opportunity to get involved and tell your side of the story. The first thing to know about complaints, ethics complaints in Florida, is that anyone can file an ethics complaint with us at the Ethics Commission. The only catch is that the complaints themselves have to be submitted on a Form 50. The Form 50 is our official ethics complaint form. You can, if you're curious, it's available on our website. That a lot of people often send us like a letter or they'll email us a news article and they'll ask us to treat it as a complaint. Okay, we have to send it back to them and say, by law, the only way we can look into an allegation is if it's attached to an official Form 50. And that Form 50 has to be signed and notarized. We do not accept anonymous complaint filings. Now, what happens when a complaint is received is that a copy of it is sent to the public officer employee that's the subject of it. A copy is sent within 5 working days of when we receive it. And it's then given initially to one of the Ethics Commission attorneys. This is the first stage of the ethics complaint process. It's called the legal sufficiency stage. And what will happen is that we as an attorney will take a look at it and we'll say, okay, accepting all of the allegations in this complaint is true. If this thing goes the distance, could it even make out a violation of one of our statutes? About half the time, complaints never make it past this initial phase. They concern sunshine law violations, or maybe they concern private capacity conduct of a public officer. And as I've already mentioned, that's not things that we have the jurisdiction at the Ethics Commission to look at. We get probably, I would say, about, maybe 250 or so complaints filed with us a year, some years more like 300. I would say at least half of them are dismissed at the initial stage of the process because they concern things that we don't have any authority to look into. Now, something new in the law is that just last year, the legislature also said that when we're looking at the sufficiency of the complaint when it first comes in, we can only refer a complaint on for an investigation if it's clear from the face of the complaint that the person filing it has personal knowledge of the allegations or that it's based on information other than hearsay, like a business record or a public record. Okay. Again, this is something new. It was just added to the laws last year. And what it means is that if somebody is just attaching a news article to a Form 50 and it's all underlined and they want us to look into something they read about in the newspaper, we have to send it back to them unless it's clear that they have personal knowledge of what the article is covering, because it doesn't meet this new investigative standard. Now, if the allegations in the complaint, though, if they're accepted as true, if they could make out a violation of one of our laws, and if they are based on personal knowledge or information other than hearsay, they have to be investigated. I think we have 7 or 8 investigators currently at the commission. Most of them are former law enforcement. Just because a complaint's being referred on to be investigated does not mean a violation is going to be found. All it means is there's enough substance in the complaint to send somebody out to figure out what exactly happened. So the investigator will go out and talk to the person that's the subject of the complaint. They'll usually talk to the person that filed it, assuming that person has some useful information to add. They'll talk to anybody else with information and they'll collect all the data and they'll compile it into a report. And the next stage of the process is the commission has to take a look at that report and say, okay, is there probable cause here to send this on for an administrative trial at DOA? Now, that probable cause stage where the commission looks at the investigator's report, again, the public officer employee is fully able to participate in that probable cause hearing. Very, very often, even if the complaint's being investigated, it doesn't make it past the probable cause stage. The commission just says, hey, look, we've looked into this. There's nothing there. Or even if there is, we don't think that there's probable cause to send it on any further for an administrative hearing. And the matter ends right there. The case is dismissed. Now, if the commission does find, though, that there's probable cause of a violation based on the investigation, it'll send the matter over for an administrative hearing at DOA. And after the hearing is complete, the commission will then make a final decision on whether or not there's been a violation. So that's the complaint process. The only other things I want to mention about this is that the entire process is confidential until the commission takes some type of public action. That means that we at the commission, we can't even reveal the fact that a complaint's been filed until the commission either dismisses it or sends it on for a hearing at DOA. So practically what that means is that if a complaint's being investigated, the commission hasn't taken any public action on it yet. So we at the commission, we can't even acknowledge the fact that a complaint's been filed with us. I will say those laws about confidentiality do not apply to the individuals that file the complaint. If they want to turn their complaint over to the media, or if they want to put it up on social media, they have the ability to do so. We can't stop them because, again, these confidentiality laws just apply to us as an agency. But again, if a reporter, for instance, contacts us and asks us to comment on the complaint, we won't even be able to acknowledge the fact it's been filed with us until some official action is taken by the commission. The only other thing I wanted to mention, and this sometimes comes up, right now, conservation districts don't have the ability to refer ethics matters to the Ethics Commission. So your district would not be able to send any matter over to us and ask it to be investigated. The law is pretty clear that we can just accept referrals from the governor's office, FDLE, or state attorney, U.S. attorney's office. So that's currently as it stands. So if an issue comes up before your district that you want to get in front of us, someone will have to file an ethics complaint about it. So that's a very long introduction. Thank you for your patience with that. I'm about ready to dig into some of our ethics statutes, but Amy, are there any questions that have come up in the chat?
Not at present. So if
Okay.
anyone has any on this first section on the complaint process, speak now or hold your question till the end, I guess. Thank you, Gray.
All right. So this is really what we're here for. Let's talk about the ethics laws. The first laws that I wanted to talk about are probably the most important to know. These are the misuse of public position statutes, and these crop up very often in ethics complaints that are referred on for an investigation. Now, these two statutes on this slide, they apply to every public officer and employee in Florida, from the governor and legislators on down to conservation district supervisors and ethics commission employees, all the way on down to, I suppose the janitor at the local high school. As long as it's a public school, they're going to be subject to these misuse of public position statutes. And as you can see on the slide here, the first statute is section 112.313, subsection 6. That's the state misuse law. And the commission can find a misuse violation when a public officer has corruptly used their position or any resources available to them in their position to obtain a special benefit for themselves or for somebody else. And the term corruptly, as it's used there, means to intentionally act in a manner that's inconsistent with the proper performance of your public duties. So if you're looking at this, here's what you really need to zero in on here. It's not enough just to act corruptly, to act in a manner inconsistent with your duties. Okay, that has to be coupled with some type of benefit that you're trying to obtain for yourself or someone else in order for it to be a misuse violation. Let's say that during an upcoming district meeting, you have someone who comes up to the podium during the public comment session, and you have a district supervisor who is unbelievably rude to that individual. They insult them. They really embarrass them in front of everyone. Okay, you could make an argument that that's corrupt conduct inconsistent with the proper performance of one's duties. But there's no real benefit to the district supervisor from that conduct. It's just a detriment to this person at the podium. So I'm not saying that you should act rudely towards the people that appear in front of you at meetings. I'm not encouraging you to do that at all. But I will say that's going to be hard to show it to be a misuse violation because while you might have corrupt conduct, the benefit prong from that is missing. Let me give you some examples, though, where the violation has been found. The courts have settled that a public officer who sexually harasses a subordinate has committed a misuse violation because they're leveraging their public position improperly to obtain some type of personal benefit. Or let's say you have a district supervisor who's using their district business card for a purely private purpose. Let's say they go to a trade convention, they start passing out their district business card. There's really no public purpose for that. It's just purely a private benefit they're trying to obtain. And so that could be a misuse of public position as well. The big point here is that the misuse law is broad, but it does require intentional corrupt conduct done for someone's benefit. Now, the other statute up there is section 112.313, subsection 8. It's going to apply if a public officer discloses confidential information. And what I mean by that is information not available to the public that they've learned through their official position. So if your district ever has a shade meeting where confidential matters are discussed, you shouldn't be releasing that information, publicly after the meeting is over, until that information is meant to be released to the public. And another interesting note here is that this subsection 8 about the disclosure of confidential information, unlike some of the other laws that we're going to talk about, that continues to apply to you even after you step off your district board. Okay, even if you're a former district supervisor, you could still be the subject of an ethics complaint if you're sharing confidential information that you learned while you were at the district that has not yet been made public. Okay, so those are the two misuse statutes. Now, I want to put that right up against a very similar misuse prohibition found in the state constitution. Okay, the state constitution has almost a variation in it on the misuse statutes that I just discussed. Again, it applies to all public officers and employees in Florida, both state and local. It's found in Article 2, Section 8H2. And what it says is that you can't abuse your position to get a disproportionate benefit for yourself, a spouse or child, an employer, or a business where you're employed or have an interest. So let's make sure that we're all on the same page here. In the statutes is a misuse law that says that you can't misuse your position to get any type of benefit, great or small, for yourself or for anybody else. And then we have a constitutional prohibition that kind of fits within that. It says you shouldn't be abusing your position to get not just a benefit, but a disproportionate benefit. And then not just for anybody, but for yourself, your spouse, your child, or your business. So the constitutional prohibition is kind of a narrow slice of the pie that is the misuse statute. It kind of fits within it. Now, a couple of years ago, the commission did engage in some rulemaking to define what some of these terms mean. And it found by rule that a disproportionate benefit is any privilege or benefit obtained by a public officer who is acting with a wrongful intent in a manner that's inconsistent with the proper performance of their public duties. So what does this mean? It means for both the misuse statutes as well as for this constitutional prohibition, you have to be intentionally acting in a manner that's not consistent with the proper performance of your duties. You have to know you're doing something wrong in order for it to be a problem. So that's something I think a lot of people get nervous about because they say, look, I'm a district supervisor. Occasionally, I might be involved in some activity by my district board that I might benefit from, but it's something that's allowed by the law. Well, that's not going to be a misuse problem under the statute or an abuse problem under this constitutional prohibition because you're not acting with a wrongful intent then in a manner inconsistent with the performance of your duties. And as long as you're following all the different rules that are applicable to you as a district supervisor, you really don't have anything to worry about. All right, the next piece of the puzzle is a little bit easier. It's the state nepotism law. Now, this is found in section 112.3135. It's a pretty clear prohibition with just one little wrinkle. What it does is it prohibits a public officer, like a district supervisor, from appointing, employing, promoting, or advancing a relative, or for advocating, going to bat for a relative's appointment, employment, promotion, or advancement. So that's pretty straightforward. Where a lot of public officers make their mistakes, though, is that it's going to apply regardless of whether or not you've actually participated in the decision to hire or appoint one of your relatives. The law says that the statute is triggered if you or the collegial body on which you're serving are doing the appointing, employing, promoting, or advancing a relative. So what that means is that if your district board is being asked to hire one of your relatives, really there's only two ways to avoid a violation. Either convince your relative not to pursue the position, or you're going to have to step off the district board. Just abstaining from the vote on appointing or employing your relative is not going to be enough because again, the statute is triggered as long as your collegial body, as long as your board decides to make that decision, even if you haven't participated in it. So that's the one area where this law gets a little bit tricky. The other thing I do want to note there is that last bullet point up there in the slide. The law only applies to positions within your agency, within your district. Okay, so if your district is not hiring a W-2 employee, they're hiring a 1099 independent contractor who's not going to be a district employee. They're going to be retaining their private status and just doing some work for the district for a short period of time. Okay. The law then won't apply because that individual won't be considered a district employee. So I think that's something important to point out. Let me just hit one more slide here and then I'll stop again for questions. These next provisions to discuss here concern dual office holding and additional public employment. The first statute up there is pretty straightforward. It's section 112.313 subsection 10. What it does is it prohibits a public officer from serving on the governing board of their agency, although also working as an employee of the agency. So if you're on the district board as a supervisor, you shouldn't also be a district employee simultaneously. That's going to trigger a problem. We see this apply very often in cases where you might have a public school teacher who wants to serve on the school board while continuing teaching. Okay, they can't do that. They're going to have to choose one or the other. The other prohibition there is 112.3125. What this says is an elected officer, so that would encompass you as district supervisors. You can't accept the job with another public agency if you know the job is being offered just so that other agency can gain some type of leverage or advantage over your public position. Like, let's say you're a district supervisor and you are offered a position with a local city or the county, okay, and you know that the city or the county is just offering you that job so they can have a little bit of leverage in your decision making on the district board. If you take that job knowing of that ulterior motive, that's going to be a violation of section 112.3125. Now, the other part of that statute also says you can take a job as long as there's no ulterior motive with another public agency, as long as you jump through certain hoops. And I put them up there on the slide. The position has to be publicly advertised. You have to apply for it and be subject to the same hiring criteria as anyone else. And you have to meet or exceed that criteria. So this law is just not in place to shut you down as an elected officer from accepting a job with another agency. It's just in place to make sure that you're being offered the job for the right reasons and that you're not getting any type of unfair advantage based on the fact that you're an elected officer. So this is a good moment for me to take one more break here, Amy. Are there any other questions that have come in the chat?
There are none in the chat. Everyone's pretty much muted, but if you do have a question at this point, go ahead and unmute yourself before we move on to the next part. All right, hearing none, we can move on to the next part. Thanks.
Okay. What I've been hitting so far has been pretty straightforward. None of the misuse laws, the nepotism laws, those are fairly easy to understand, but we're going to kind of get into the weeds here with these next couple of statutes. These laws, there's two of them, deal with doing business with your agency. Situations where you might own a business or be employed by a business that's conducting business in some way with your district. This is a big part of a lot of opinions that the commission issues, those formal opinions I was talking about. Now, like I said, there's two statutes here. The first one is section 112.313, subsection 3. And this law deals with ownership. It deals with situations you might have a public officer or an immediate family member, like a spouse or a child, who is conducting business with the officer's agency. Okay, and there's two prongs to this statute. There's two parts to it. First, and I'm just going to read it to you. The statute says no employee of an agency acting there a capacity as a purchasing agent shall purchase, rent, or lease any realty goods or services for their agency from a business where they or their spouse or child is an officer, partner, director, or proprietor, or has a material interest. And a material interest is defined in the law just to mean you own over 5% of a business. Okay, so what does this mean? Well, it means that if you're an officer or a director of a business, or if you own over 5% of it, you shouldn't, as a district supervisor, then be involved in purchasing something for the district from your business. And the same thing would apply too if it's your wife's business or your husband's business or your child's business. You shouldn't be purchasing anything from one of those businesses either. Now, like I said, there's two parts to the law. The second part just says the same thing, but kind of in a different way. It says in your private capacity, you shouldn't be renting, leasing, or selling any services to your own agency. So this kind of gets you coming and going. You shouldn't be buying anything from your business in your public capacity, and then privately, you shouldn't be selling anything to your agency as well. Now, there are some exemptions to these doing business laws, and I'm going to be covering them in just a couple more slides because these exemptions actually apply to this law and the next one we're going to be discussing. But I do want to note, written right into this particular statute, 112.313 sub 3, is a grandfathering exemption. Okay, it applies to the agreement to sell goods or services from your business to your district was brokered and in place before you were elected to the district board. Okay, so let's just say that you are a plumber. Okay, and for the past 20 years, you've been under a contract to serve the district's buildings. Okay, that contract was in place before you were elected to the district board. Okay, in that case, as long as it preceded your election, that contract will be considered grandfathered. It won't trigger a problem under section 112.313 subsection 3. The only thing I will say is that if you do decide to renegotiate that plumbing contract while you're on the board, any new contract that you form would trigger the statute because you wouldn't be talking about the grandfathered agreement anymore, but an entirely new arrangement. So that's the first doing business law. Basically, if you own a business or you're an officer of a business, don't be selling anything to your district. Okay, the next statute here deals with when you might not be an owner, but just an employee of a business that's interfacing with your district. As found in section 112.313 subsection 7A. There's two parts to it. First part's pretty mechanical and just sets out a couple of elements, and if you meet them, you can have a violation. What it says is that a public officer employee can't be employed by or enter into a contract with a business entity that's either being regulated by their agency or is doing business with their agency. So essentially, this is going to prohibit you in your private capacity from transacting some type of contract or entering into an employment relationship with a business that's interfacing or doing business with your district. Let me give you an example. Let's say you're a district supervisor and your district, I don't know, needs to build a customized van for district purposes. And so you contract with an equipment manufacturer to build you this van. And let's say that simultaneous to that, you're a farmer. And you also contract with that equipment manufacturer to build you a brand new tractor. Okay. In that case, you would technically have a contractual relationship with a business entity that's doing business with your district, with your agency. That checks all the boxes. That could be a violation of this first part of the statute. And so that's just an example of when you're going to have to be a little bit cautious. And now the second part of the statute is more situational. It's going to depend on the facts of each situation. It says that you can't have or hold any employment or contractual relationship that'll create a continuing or frequently recurring conflict between your private interest, the performance of your public duties, or that could impede your ability to discharge your public duties. Now, I want to emphasize the Commission views this as a preventative measure. It has opinions that say if you even have an outside employment or a contract that could even tempt you to compromise your responsibilities as a public officer, you could have a problem under the second part of the statute. Let me give you an example of this as well. When I first started working at the Commission, we issued an opinion to a police officer. And that police officer wanted in his spare time to take on private investigative work, and he wanted to do a wide variety of private investigation services. One thing that he wanted to do was work on the surveillance of suspected shoplifters. I guess different businesses were going to hire him to do that. and he wondered if that could present a conflict with his duties as a police officer. The commission looked at that and found that it would trigger some concerns under the second part of the statute because it found that he could be tempted to speed along his private investigation by looking at some criminal files on area shoplifters that were confidential and only available to him in his status as a police officer. So the commission said, look, your private interests could come into conflict here with the objective performance of your public duties. You could be tempted to sneak a peek at that information. So you can't accept those kind of cases, at least under 112.313 subsection 7A. Okay, so those are the two doing business statutes. Now, I think I mentioned this before, but there is a whole list of exemptions to these statutes, both to section 112.313 subsection 3, where you're an owner of a business selling something to the district, as well as to 112.313 subsection 7A, where you're employed by a business doing business with the district. And I just want to run over a couple of them for you. I will say that if you ever have a scenario where you think one of these statutes might apply, talk to your district counsel, give us a call at the Ethics Commission. We can clarify for you whether we agree that you have a violation of these statutes. And we can also move on to look at whether or not any of these exemptions might apply to negate it, because oftentimes that's the case. The exemptions themselves are laid out in section 112.313 subsection 12. The first exemption up there is if your conservation district badly needs a good or service and your business is the only source of supply of it within the four corners of the district. Okay, that would negate a conflict. Or if it's an emergency purchase, let's say there's a natural disaster rolling into your area. I know we're heading into hurricane season here, and your district needs to get something from your private business to deal with an impending natural disaster. Emergency purchases are also exempted from the reach of the statutes. Now, it has to be an actual emergency purchase. If the hurricane's already gone through, that exemption is not going to apply. But if you've got a storm bearing down and your district needs to get something quickly, an exemption could be recognized in that circumstance. Also on this list is if your company secures the business through the process of sealed competitive bidding, or if the total amount of business transacted between your private business and the district is less than $500 in a calendar year. Okay, those are just a couple of the different exemptions that are laid out in the statutes. These doing business laws are tricky. They're very nuanced. So if you have questions about their applicability to a particular situation you're involved in, give us a call at the commission. Let us work through it with you, preferably before any business is conducted, to make sure you're free and clear under one of these exemptions to go ahead and do what you want to do. Now, with that being said, I'm going to transition now to talk about voting conflicts. But before I get there, let me just give you one more word of warning that's kind of related to these doing business statutes. The voting conflict law that we're about to talk about operates on a whole different track than these doing business statutes. It operates independent from them. And that means if you have a vote coming before your district that is going to place your business in some type of business arrangement with the district, and you abstain from the vote, okay, you may have properly handled the voting conflict then, and we're going to talk about how to handle a voting conflict. But just because you properly handle the voting conflict doesn't mean that you're free and clear under these other doing business statutes. Again, they operate on separate tracks, so you've got to make sure that there's an exemption that would apply to cure any conflict under them as well. Just abstaining from the vote is not going to be enough to get you off scot-free under all of these laws. So that's one thing that I did want to emphasize, because I think a lot of people unfortunately think that as long as they step back from a vote, they don't have any problems under the state ethics laws concerning the measure. And that's not always the case, particularly if your business is going to be, after the vote, doing business with your district. But let's move on now to talk about that voting conflict law. This is a major area of the Code of Ethics. It's found in section 112.3143. That's the voting conflict statute. And the particular area of the law that applies to local law officers is found in subsection 3 of that law. What it does, and this is probably good to clarify up front, is it hinges on special private gain or loss. Maybe for some of you this isn't new knowledge, but special private gain or loss is kind of the buzzword when it comes to voting in Florida, at least under the Ethics Code. And that's defined in the law to mean some type of economic benefit or harm. Now, if you look at the voting conflict law, there's really two ways you can have a conflict. Both of them hinge on finding special private gain or loss. Okay. And the first way that you can have a conflict is if the vote's going to bring special private gain or loss to you personally. If a vote being taken by your district is going to have an economic effect on you, could be a benefit, could be a harm, you have a voting conflict. And something that I don't think a lot of people understand about the voting conflict law is that it doesn't have any intent requirement in it either. Okay. Even if you didn't realize the vote was going to financially affect you at the time that you cast it, somebody could still file a complaint against you about it. And unless an exemption is found, a violation could occur because of that vote, even if you didn't realize at the time that it was going to financially affect you. So that's the first way you can have a voting conflict, is the vote's going to have some type of economic effect on you. The second way is if the vote's going to economically affect someone else. Now, this second way does have a knowledge requirement. There's an intent there. It says you can't vote on a measure if you realize at the time of the vote that it's going to bring special private gain or loss, financial benefit or harm, to a principal, relative, or business associate. Okay, so you've got to be very, and those terms I will say are all defined in the Code of Ethics, principal, relative, and business associate. So you got to be very careful about different votes you're facing. If it's going to financially affect you or a principal, relative, or business associate, you could have a voting conflict. Now, a lot of people call in and they're upset because the board that they went to a board meeting and they don't feel the board is following Robert's Rules of Order, or they don't feel that the board had a proper quorum prior to the vote. Okay, that may be the case, and that may violate some internal procedural rules, but there's nothing about the quorum requirements or Robert's Rules of Order in the state code of ethics. So those wouldn't be violations that we'd be able to take any action on. In order for a vote to be something that falls within our jurisdiction, there has to be special private gain or loss resulting from it, either to the voting officer or to a principal, relative, or business associate. So let's say you've got a vote, though, that could qualify for that. It could financially affect you or let's say a relative. What do you do then? Well, warning bells should be going off. You should be saying to yourself, this vote could be a problem for me. But that being said, there are still three considerations. Even when a vote's going to have that type of economic effect, there's still three considerations that could cure the conflict. And I find that a lot of people have some knowledge of these, so hopefully this isn't new for you. Okay, the first consideration is what's the size of the class that's going to be affected by the vote. All right, the general thumb is that the larger the class size, the more people that are going to be financially affected by it, then the less and less likely that the gain or loss will be considered special. Remember, unless it's special private gain or loss, it's not going to be a voting conflict. If we're dealing with a large class size, like let's say the vote's going to affect you and a couple hundred other people, okay, then you're just experiencing the same type of financial effect that many other people receive as well, and it won't be a voting conflict. The commission has found in the past that as long as there's at least 100 other people that are going to be affected financially in the same way as you, the size of the class consideration will cure that voting conflict. The second consideration is whether the gain or loss is remote and speculative. And this comes into play when it's possible, but it's uncertain, it's unlikely at the time of the vote that you or a principal, relative, or business associate are going to be economically affected by it. And if there's a possibility of a financial effect, but it's remote and speculative, special private gain or loss won't be found. Okay, and then third is when the measure is just preliminary or procedural. Okay, if the measure is going to have no actual effect on you, it's just a preliminary measure before you get to the main event, it's not a voting conflict. Like a good example of this is, let's say that you're faced with a proposal to accelerate or postpone a particular vote, which you know you're going to have to abstain from. You know that underlying vote is going to economically affect you. Well, even if you have to abstain from the underlying vote, you can still probably vote on the preliminary measure concerning the timing of the underlying vote. Because just figuring out when the underlying vote is going to take place probably is not going to financially affect you. So again, those are the three considerations that could apply to cure a voting conflict. They're pretty straightforward. Now, the commission has a whole slew of opinions on this, though. So if you've got a vote coming up on the agenda that you know might have some voting concerns for you, give us a call at the Ethics Commission. We can work through it with you to make sure that one of these exceptions might apply to cure it. Now, if you talk to us though, and it looks like none of these exceptions will apply, how do you handle a voting conflict? Well, it's pretty easy. There's three steps here to take. First, you got to abstain from voting on any measure which will bring special private gain or loss to you or which you know will have that effect on a principal, relative, or business associate. If you know it's going to be a conflict, you got to abstain from the vote. Second, prior to the vote, you've got to disclose the conflict publicly. And then third, within 15 days of the vote, you've got to file the Form 8B. Now, the 8B form is a form that you can find on the Commission's website. I'm sure that your district council could probably also get you a copy of it as well. It's a pretty easy form. You just put down on it your name and position, the day of the vote, and then you got to explain why you have a conflict, why you're abstaining. And then you've got to file that form with whoever records the minutes of your agency meetings. Okay, so those are the three steps here. Abstain, disclose the conflict publicly before the vote happens, then get that Form 8B filed within 15 days of the vote. Okay. A couple other things that often come up when you're filling out that Form 8B, people sometimes ask, how specific do I have to be? Well, be as thorough as you can be. You don't have to write a book, but put down at least enough so that somebody will be able to look at the form and understand why you have a conflict. And that means, too, that if the vote's going to affect both you and a principal or both you and a relative, make sure to list all the different reasons for the conflict on that form as well. And the last thing up there, people often call in and wonder, they say, look, I've got a vote coming up that I have a conflict on. I'm planning to abstain. Do I have to leave the room while the vote is happening, or do I have to step off the podium? There's no requirement in the state law if you've got to leave the room or step off the podium while the vote's happening. Might not be a bad idea. It would remove certainly any appearance of a conflict, but it's not a requirement. Again, the only requirement is that you abstain, disclose the conflict, get that form filed within 15 days of the vote. That wraps up what I was going to say about voting conflicts. Do we have any questions, Amy, on anything we covered so far?
We have one that actually came in earlier that relates to this, and that is just the means of voting. So it's not possible. You have to vote either yay or nay. Obviously, you cannot vote present in these situations to try to avoid that conflict. And we have somebody
Yeah.
else. Go ahead.
Yes, some officials think that the word present can be used to avoid non-financial conflicts of interest, where they just feel they can stay present and not make a moral or a other type of conflict of interest. And it's come up both at city council and in our district where they've not wanted to vote. And I have not seen anywhere in the ethics course or in the statutes anything about anything other than financial.
Sure. Thank you for that question. Again, in order to have a voting conflict under the state law, there has to be some type of financial effect, either to you or to a principal, relative, or business associate. That's the only way, under the state law at least, that you could have a voting conflict. If someone just decides to vote present during a meeting instead of yay or nay on a particular motion, that's not really addressed in the state code. I'm wondering maybe if it's addressed in the local bylaws and ordinances that would apply to your particular district, or I suppose it might be addressed in the statutes that pertain to conservation districts. There's nothing in the code that specifically addresses whether voting present is proper or not. That would be more, I would think, an internal thing. You'd have to look at the laws that pertaining to your specific board. That's outside the code of ethics itself.
So even though the state says this is the only option, it could be legal in the district?
I guess I'm not sure of your question, ma'am. Like I
Okay,
said,
it's not legal at the state. So how could we then turn around and make it legal locally because it wasn't in the bylaws?
you're talking specifically about someone who just votes present during a vote instead of yay or nay.
Right.
Right. It may be in the state statutes, but it's not addressed in the code of ethics itself.
Okay.
That in itself wouldn't be a voting conflict. What I'm talking about here tonight is just specifically what's addressed in the voting conflict law, section
Okay.
112.3143. And the only way that a vote could be a conflict is if it's going to financially affect the public officer or their principal relative or business associate. The mechanics of voting and the mechanism of how you get there and how the vote's taken, that's not something that the Ethics Commission is involved in.
Okay. Thank you.
Sure. Well, we have one more big subject that I want to cover tonight, and that is something that I think a lot of people often have questions about when I talk to them, and those are the state bribery and gift laws. So I want to take a few minutes and talk about these before we close out tonight. Right off the bat, I'll tell you, we've been working up to this. This is probably the trickiest area of the state ethics laws, so I'm going to kind of really slow down here and make sure that we're all on the same page. I like to think of gifts like an onion that you're peeling. You're peeling back the layers of the onion to get to the core of it. Hopefully, it's not going to make you cry. Uh, as we work through each of these different layers of the gift onion and we peel them back, I want to make it very clear for you who these layers apply to. Some of these gift laws apply to everybody at your district, all officers and employees. Some of them are just going to apply to you as district supervisor. And if somebody offers you something, the first layer here of the gift onion, the first question you should be asking is this a bribe? Is this being given with the expectation of me taking some action in return as a district supervisor? Okay, there's two statutes involved here. Both of these bribery statutes apply to everyone. They apply to all public officers and employees, district supervisors, district employees. Too. And it's pretty simple. It says a public officer employee can't solicit or accept anything of value based on an understanding that's going to influence some public action they have to take. Okay, if somebody comes up to you on the street and they give you a suitcase full of money and they say, I want you to vote this way on this particular issue at your next meeting, and you take that suitcase, you've taken a bribe, and that's obviously going to be a problem under the state ethics laws. The only catch here is that for this statute to apply, subsection 2, there has to be an agreement between you and the person giving you the bribe that you're agreeing to take some public action in return, that you're agreeing to take a bribe. That's a very hard thing to prove unless the public officer and the person giving the bribe are both willing to testify that a bribe is going down. So it's an easy statute to understand, but it's a hard statute to actually prove. And because of that, I think the legislature passed the other law up there, section 112.313, subsection 4. This goes deeper. It says if somebody gives something of value to you or your spouse or child, and you take it, even though you knew or you reasonably should have known under the circumstances at the time that it was being given to influence your public actions, you could be held in violation. Okay. So this is a little bit more general than somebody just reaching an agreement with you that you're taking a bribe. If somebody gives you the keys to a new sports car and they have a measure that's going to directly affect them at an agency meeting you're going to have next month, and you take those keys, now they may not have asked you to take any action in their regard, but under the circumstances, you should have realized there could have been an ulterior motive there. And so if a complaint is ever filed about that, it could be investigated under section 112.313, subsection 4. So that's the outer layer of the gift onion, the bribery laws. Again, they're a little bit easier to understand. Let's peel that back and talk about the next layer, which is the gift law itself. And the gift law is found in section 112.3148. This is where all the other gift rules can be located. And the first order of business is figuring out who this layer of the gift onion applies to. The gift law itself is very specific. When it comes to the local officers in Florida, it only applies at local agencies to those who file a financial disclosure form. So you as district supervisors, you have to file a Form 1. Because you file a disclosure, that means you're subject to the different requirements in the gift law. Now, before I tell you what the gift law is going to prohibit, let me define a couple of terms for you that are important to know. And the first is, what do I mean by the term gift? We've got to be clear on that. The answer is that the term gift means anything of value. So it's a pretty broad-ranging definition. Okay, it could include if somebody takes you out to dinner or buys you a drink, that's an item of value that has a gift. But it's also going to cover things like if somebody offers to mow your lawn, or if somebody lets you stay in their property on the ocean for the weekend. Those things are quantifiable as well. They have a value to them. So if you take them, you got to understand that they do qualify as a gift under the gift law. Now, just because somebody's offering you a gift doesn't mean it's off limits. It just means, as we're going to talk about, you have to be a little bit careful in thinking through things before you take it, especially if it's coming from an agency, vendor, or lobbyist. I don't know if your districts have a lot of vendors, but if you have a company that's doing business with your district, they would be considered a vendor. And as we're going to talk about, you got to be careful about taking gifts from them. You've also got to be careful about taking gifts from lobbyists. Now, the term lobbyist is defined in the gift law. It's defined as any person who, for compensation, has tried during the previous year to influence decision making at your agency. So basically, any attorney appearing before your district, let's say, they would be a lobbyist if they've appeared within the prior year, because during the past year, they've tried to influence your decision making. Now, if that attorney is trying to influence the next district over, but he had no business before yours, he wouldn't be considered a lobbyist of you. We're just looking at the people who have tried in the past year to influence decision making at your district. So that's what the definitions are in the gift law. Let's talk about what the gift law prohibits in this layer of the onion. There's a couple of things to note here. The first is that the gift law says that you, as a reporting individual, disclosure filer, you can't solicit any gifts at all from lobbyists, principals of lobbyists, or vendors of your agency, of your district. Okay, so soliciting means asking. You can't ask a district vendor or lobbyist for a gift of any amount. Okay, there's no dollar requirement attached to it. So if you're asking an attorney before your district to even buy you a cup of coffee at Starbucks, that technically is going to trigger this solicitation ban. That would be a problem under the gift law. But if you have a situation where you're not soliciting the gift, the lobbyist or vendor just approaches you on their own and they offer you something. Well, think about the gift onion. If you have a lobbyist or vendor offering you something, the first layer of the onion is, do they want me to take any action in return? If they do, it's a bribe, and you've got to turn it down under that first layer of the gift law. But let's say there's no strings attached. They say, look, I may have had matters in front of you within the past year, but I have nothing on the books right now. Can't I take you out to lunch? Okay, well, that leads to the next provision up there, which is that you can't accept a gift of over $100 from a lobbyist, a principal lobbyist, or a vendor of your agency. So you can't ask for the gift if it's a vendor or lobbyist, and you're precluded at taking it if they're offering it to you and it's more than $100. So let's say you got an attorney who's appearing before you in a district meeting and the meeting's over. He says, look, there's nothing that my firm has coming up before anytime soon. Can I take you out to eat at McDonald's? Okay, and he buys you a Big Mac meal. Now, the value of that is going to be less than $100, so that's okay. But if he takes you and your wife out to Olive Garden and he buys you, appetizers and wine and dessert, and the bill for you and your wife is $200, that's going to be a problem because that is a lobbyist of your agency and he's offering you a gift of more than $100. Now, the last point up there on the slide is a little bit different. It deals with political committees. This probably isn't going to rise all that often, but the law says that as a disclosure filer, you can't solicit or accept a gift of any amount if it's coming from a political committee. That's a very firm No on that. The only exception to that is if the political committee is offering you something that's related to some political activity you're engaged in, like if they're making a campaign contribution if you're running for office. That obviously is allowed. But otherwise, you shouldn't be asking or accepting any gifts from a political committee. So let me review what we've covered so far. First layer of the onion, is it a bribe? Do they want me to take something in return? Second layer of the onion just applies to you as a disclosure filer. You shouldn't be asking for a gift of any amount from an agency, vendor, or lobbyist. You shouldn't be taking a gift from a vendor or lobbyist if it's valued at more than $100. Those are probably the hardest things to understand. But let me move on now to the inner layer of the onion. What does the gift law have to say about gifts that are not bribes? They're not coming from vendors or lobbyists of the district. These are just gifts from relatives or from friends. What do you do then? Well, this inner layer of the onion, this slide also just pertains to the gift law, so it just is applicable to you if you're a disclosure filer. Let's talk about relatives first. The term relative as is defined in the gift law is very broad. There's a list of them in the statutes, and it's going to include your spouse, your parents, your grandparents, your children, fiancés. It's a very long list. As long as the person is listed as a relative in the gift law, you can take a gift from them no matter the amount. Okay, and there's also no reporting requirement either. You don't have to even acknowledge the fact that you've taken an expensive gift from a relative. Now, let's say the gift though isn't coming from a relative, but just from a friend. Maybe your next door neighbor buys you a Christmas present, or your boyfriend or girlfriend wants to take you out to dinner for your birthday. Well, in those instances, you as a reporting individual, you can take that gift from that friend. But in those instances, because they're not relatives, you may have to report it. What the law says is that if you're taking a gift from a friend that's worth more than $100, you've got to report it on what's called a Form 9. Now, the Form 9 is a particular form you can find on the Ethics Commission's website. It has to be filed for every calendar quarter in which a reporting individual takes a gift of over $100 from a friend or even a community organization. And on it, they've got to disclose each gift they've received during that period that exceeded $100, and then they'd file it with the Ethics Commission. And if a particular calendar quarter goes by in which you don't accept a gift of over $100 from a friend, you don't have to file the form. So that's the gift law in a nutshell. Again, just to run down the highlights, don't take a bribe. Don't ask for gifts from vendors or lobbyists, and make sure that if a vendor or lobbyist is offering you something, that it's not a bribe and that it's worth $100 or less. When it comes to relatives, take any gift that you want. When it comes to friends, take the gift, but just disclose it if it's more than $100. That's the gift law in a nutshell. And I know that I'm almost out of time. I know that we're a little bit past 7 o'clock. I just have two last slides to hit very briefly before I close. And then I'll also open it up if there's any other questions that have come in. Financial disclosure is another area of the Ethics Commission. I could spend a whole hour talking about how to complete a disclosure form all by itself. But I just wanted to take one slide here and hit the highlights for you. As you can see there, as a soil and water district supervisor, you've got to file the Form 1. And that's because the law requires local elected officers of political subdivisions to file the Form 1. The due date for the form is July 1st, with a grace period that extends to September 1st, where you won't accrue any type of penalty. So if you haven't filed your Form 1 yet, just make sure to get it submitted by September 1st of this year. I will say that if you look at your form and you realize you've made mistakes on it, which happens, I know it's happened to me, there is a way for you to amend your form. It's called the Form 1X. Now that 1X form looks just the same as the Form 1. You just fill out the individual sections that need the changes, then you file it. And if you notice a mistake before the grace period expires on September 1st and you file the 1X, that's just considered part of your original filing. The last point up there is that if you don't file by the end of the grace period by September 1st, you will start to accrue a $25 a day fine. So again, if you haven't filed your financial disclosure form yet this year, you've got a couple weeks left to do it before Labor Day. Make sure to get that in. One last thing that's not up there on the slide, I'm sure all of you are aware of this, but we recently shifted away from paper forms. The law changed and it said the only way people can file disclosure now in Florida is electronically. And the commission was charged with developing a system where people could log in and fill out their form electronically. If you ever have questions about how to navigate that system or whether you need to put something down on your Form 1, give us a call at the Ethics Commission. We get those calls every day. We're glad to take them. And our job, again, is to help you and help you figure out how to properly complete that form. This last slide deals with post-office holding restrictions. These are the laws that are going to continue to apply to you even after you leave your district board. We've already talked about one of them up there, 112.3 and 3 subsection 8, and don't share any confidential information you've learned as a district supervisor. There is another law up there as well, 112.313 subsection 14. This is a lobbying ban. What it says is that elected local officers in Florida for 2 years can't represent another person or entity for pay, for compensation, before their old government body. So this is going to apply to you as a district supervisor. For 2 years after you step off the board, you can't take on some type of client that wants you to represent their interests for pay before the board. So that's a 2-year lobbying restriction. Now, obviously, this doesn't apply if you have some personal matter that you want to appear before the board for in your own capacity. If you're just there on your own behalf, that's not what this law is designed to address. This is when somebody is actually paying you to represent their interests before your board. Lean on your old board members and your contacts at the board. You can't do that for 2 years after you leave your position as a district supervisor. That was kind of a whirlwind tour of the ethics laws. Amy, do we have any other questions on gifts or anything else I talked about tonight?
Let's see. We have one question in the chat. If a relative gives you a gift to influence vote on an issue, the issue does not affect the relative, but is on behalf of a business that the relative does not work for. What would be the implications there?
Right. I want to be careful before I answer that, just to say that while I can give you general advice, I want to be careful not to comment on any particular matter because it'd be inappropriate for me to weigh in on behalf of the commission and tell you that in a particular instance something is or isn't an ethics violation. I will say in general, what the gift law says is that you can take gifts from relatives of any amount. You don't have to report them. And I don't think I covered this in the presentation. The only exceptions to that is if it's intended to be a bribe or if they're giving you the gift on behalf of a political committee. So those are two exceptions to the general rule that you can take anything you want from a relative. If the gift is intended to influence your public actions, it is a bribe, and that could be a problem under the ethics statutes. And that being said, whether or not something in a particular instance is a violation is going to depend on the individual facts of the case. So I wouldn't want to comment on any particular facts. But I will say that the bribery statutes do apply, even if it's a relative offering you the bribe.
Thank you. All right, we don't have anything else in the chat. Folks, this will be last chance for questions for Mr. Schafer. And if you want to go ahead and unmute yourself and ask a question, feel free. All right, sounds like we are good on questions. And you have the contact information there should you need to contact Mr. Schafer for any questions in the future. Thank you very much. I want to just extend my appreciation. This has clarified a lot of issues, and I appreciate you making this available online so that we can accommodate people that weren't able to be here tonight. I feel like we have a really good update since 2019. Thank you.
It was my pleasure. It's good to be with you all.
Okay, so that will conclude our meeting for tonight. Don't forget, October 2nd, we have our overview of Florida Sunshine and Public Records laws coming up with Pat Gleason, Special Counsel for Open Government Office of Attorney General James Uthmir. I hope I am pronouncing that right. I am horrible. I asked for a canopy bed when I was a child. That's how my pronunciation goes. Um, and I want to thank everybody for attending tonight. If you weren't able to attend, please let if you have fellow supervisors who weren't able to attend, please let them know that all of these will be on our YouTube channel for future watching. Mr. Schafer, thank you so much.
Thank you. Good night.
Thank you.
Thank you.